Welcome to the Melling Law Self-Help Library. Today we're going to talk about Utah's Advanced Healthcare Directive. It's a standard form that we established as a state in 2009, and what it does is it allows us to nominate, or rather appoint, someone as our healthcare decision-making agent. If we're not in a position to make healthcare decisions for ourselves, we have a say in who should be able to make those decisions for us. By default, usually that decision would go to someone like a spouse or a parent or a child or a sibling. But this form lets us state affirmatively who we really want to be able to make those decisions. It also helps eliminate the need for guardianship in many cases. Some cases, a guardianship may still be needed if someone has lost capacity to make their own healthcare decisions. But in many cases, especially for purposes of most medical facilities, retirement homes, and assisted living centers, it helps avoid the need for a costly guardianship proceeding in court if there's already a decision maker appointed. So keep on watching and we'll show you how to fill out the form.
This is our healthcare directive form established by the Utah State Legislature back in 2009. It's part of a nationwide uniform act, so for different states these forms look pretty similar for the states who have adopted it. This first little bit is important. You do need to list your contact information here, and then we're nominating a healthcare agent, someone to make those decisions on our behalf if we're ever incapacitated or can't make those decisions for ourselves. And this is only medical. This has nothing to do with financial powers or anything like that. So if you fill out this little section on B that for your agent and all your agent's information, as well as an alternate agent, that's pretty self-explanatory, just completing contact information. Page 2 has information about what information you are giving to your agent, or which powers rather, and then other authorities. I almost always recommend that we initial yes on E, because that letter E is going to basically get rid of any red tape that the hospital may have as far as certain disclosures, and we never want any red tape when it comes to healthcare decisions and your agent. Usually on F, we won't limit or expand authorities of the healthcare agent unless we're really adamant about a particular thing, certain religious preferences perhaps. Now G here on nomination of guardian, if you want to nominate the person you've appointed as agent as your legal guardian, should you ever need one, you would do so here an initial yes. H and I are purely personal preference, whether you want to authorize your agent to consent authorize your agent to consent to your participation in medical research or clinical trials, and whether you want your agent to be able to consent to organ donation. Page 3 is what we call the living will component of this form, and that is going to allow us to decide what we want as far as end-of-life decisions. There are 4 different options here. Option 4 it basically says you do not wish to express any preferences about healthcare wishes, and that's just if you're using this to appoint a healthcare agent but not necessarily make any healthcare decisions. Now, these other 3 options, option 1 lets your agent decide, and that says you have chosen your agent carefully and you have talked with them about your healthcare wishes and you trust them to make those decisions for you. Option 2 is that you want to prolong your life regardless of any prognosis, and it does limit that prolonging to anything that is acceptable within the limits of healthcare standards. So this isn't, keep you alive at all costs, but just to the extent that is acceptable under generally accepted healthcare standards. Option 3 is a little more nuanced. If you want to basically have someone pull the plug, so to speak. If that's your purpose in signing this directive, then you will want to read over these options very closely and fill it out as you wish. Or if you believe your agent will simply do so, then option 1 is also acceptable. And finally, page 4 has any additional instructions about healthcare wishes, especially if you have any religious preferences. Maybe you are adamant about not receiving any certain types of procedures. You would want to make that known here. And then there's some information about how to revoke the directive. Read that carefully, and as well as making this effective. So right here in the middle of the page, you just date, sign, and put your city, county, and state of reference. And then your witness will sign here at the bottom. And you'll have your witness read this very carefully to make sure that your witness is not somebody who is forbidden by law to be able to sign this. So as long as none of those provisions apply that are listed there, then your witness can go ahead and sign. And then go ahead and keep this document on file with your healthcare provider or your primary care provider and have them upload it to the system of your regional hospital. If you have any questions, you can always reach us at mellinglaw.com or at 435-572-0807.